Hello, my name is McCulloch. I'm a retired builder, and I've done quite a bit of research into the legal and political situation in Australia, and on this DVD I intend to deal solely with the Queen of Australia and her authority to appoint governors and Governor-Generals. So I'll start with what we call our Constitution. This is the Constitution. The full title of this document is An Act to Constitute the Commonwealth of Australia, 1900 UK. And on the first page of this Constitution, it tells you the Australian Constitution was passed as part of a British Act of Parliament, part only. And it also says the Constitution itself actually starts at page 2, clause 9. Now, a lot of people don't understand that the first 8 clauses are covering clauses, and we cannot change them even by a referendum of the people as per section 128. They are out of our reach. And also at the rear of the Constitution is the schedule and the oath that all politicians must swear before they take their seat in the Parliament. And this also is outside clause 9 and cannot be changed. And it also says the Act containing the Constitution was passed by the British Parliament in Westminster in 1900. So this was, and still is to this day, British law. And we'll even see that confirmed later on by the High Court of England. Now, there are very few rights in this Constitution, very few indeed. And I guess there didn't need to be, because as a colony, which this is for, a constitution for a colony, we had the rights to our inherited British laws such as Magna Carta and Bill of Rights and so on. However, the High Court tells us we no longer have those, as you will see later on. So this is our problem. We have very, very few rights that we can take to court and say that these are our inalienable rights. Now, clause 2 of the first 8 clauses that we can't change reads, the provisions of this Act referring to the Queen shall extend to Her Majesty's heirs and successors in the sovereignty of the United Kingdom. So wherever you read the Queen in this Constitution, that is the Queen it's referring to, in the sovereignty of the United Kingdom. There is no Queen of Australia in this Constitution, and there is no provision for the government to create such a head of state and give that person authority to appoint governors and governor-generals. It is simply not here. And clause 8, which is the last one we cannot change, states, after the passing of this Act, the Colonial Boundaries Act 1895 shall not apply to any colony which becomes a state of the Commonwealth, but the Commonwealth shall be taken to be a self-governing colony for the purposes of that Act. So that makes it quite clear that this is a constitution for a colony, not for an independent sovereign nation as we are told we are now. Okay, so I wrote to the Lord Chancellor's Department in London, and I asked them if they had changed clause 2 to the Queen of Australia, and if they had given that Queen the authority to appoint governors and governor-generals. And the reply I got back was from the British Foreign and Commonwealth Office, and they stated, the Queen in her role as Head of State of the United Kingdom, and as such advised by British ministers, has no executive power exercisable within the Commonwealth of Australia. Now, executive power is the executive government, which comes under section 61, and it says, the executive power of the Commonwealth is vested in the Queen and is exercisable by the Governor-General as the Queen's representative. Now, as I said, wherever you see Queen, that's the Queen of the United Kingdom, and here they are telling us that that Queen no longer has executive power. So the Queen of the United Kingdom, according to the British Foreign and Commonwealth Office, can no longer appoint Governor-Generals. And it goes on here to say, the monarch's role as Queen of Australia is separate from her role in relation to the United Kingdom, and in its fulfilment she is advised by Australian ministers. So they're making it quite clear that the Queen of Australia is a totally separate legal entity to the Queen of the United Kingdom. So I wrote then to Her Majesty's Printer of Acts of Parliament, and I asked for a copy of an Act to constitute the Commonwealth of Australia as it stood in law at that time, and this was in the year 2004. And I did this purely to make sure that Clause 2 still read the same. And it does. It says, the provisions of this Act referring to the Queen shall extend to Her Majesty's heirs and successors in the sovereignty of the United Kingdom. So it hasn't been changed, and it is still not changed. That is still how it stands in British law today. Now, Heather Hill was elected to the Senate for One Nation, and there was a court case, Sue versus Hill, in June 1999, and they challenged her authority or ability to be able to sit in the Senate because she came to Australia at, I think, 13 years of age from Britain, and she still had British citizenship and she was still a subject of the Queen. So this is the court decision, and the question asked of the court was the first respondent, Heather Hill, at the date of her nomination, a subject or a citizen of a foreign power within the meaning of S44 of the Constitution? Answer, yes. And they went on to say, in the same decision, at the very latest, the Commonwealth of Australia was transformed into a sovereign independent nation with the enactment of the Australia Acts. The consequence of that transformation is that the United Kingdom is now a foreign power for the purposes of S44 of the Constitution. S44 of the Constitution, just please remember that because that'll become significant later on. So the High Court has clearly ruled that Britain is a foreign power, and in these decisions they mention that 4 times. For instance, later on they said, as indicated earlier in these reasons, we would give an affirmative answer to the question in each case stated which asked whether Mrs. Hill at the date of her nomination was a subject or a citizen of a foreign power within the meaning of S44 of the Constitution. So, quite clearly, the High Court has unequivocally ruled that Britain is a foreign power. Now this is Holsbury's Laws of England, which is the Bible of British law, and this is the 2nd edition, volume 6. I photocopied a small section of it, and it states here, the King may not rule his subjects as King of any foreign country, but only as King of England and the dominions belonging thereto, as expressed in the royal title. So even under their own British law, the Queen cannot be Queen of Australia, with, I might add, the authority to appoint governors and governor-generals, and still be Queen of England. It's not even allowed under their own law. Okay, now, Tony Abbott came to a meeting in town here, and it's pretty rare that you get politicians to come to a public meeting, so I went along, and I asked him for some documents. I said to him, I want you to send me documents. I do not want you to answer the question because I know you'll speak for 10 minutes and not answer the question. So I'll deal with 2 of the documents I asked for. And one was the document that overrides the UN Charter and allows British law, the Constitution, to be used in Australia, given that Britain is a foreign power. Okay, well, the High Court has ruled Britain's a foreign power, and this is still unquestionably British law. And I mean, it makes sense, doesn't it? You wouldn't have German, French or Italian or Russian law or whatever as the main law in Australia. So if Britain is a foreign power, then it just doesn't make sense to have the law of a foreign power the superior law in Australia. And I also asked for the document that overrides section 44 of the Constitution, allowing MPs to swear allegiance to a foreign power and sit in Parliament. You remember S44 was the one they ruled Heather Hill out on because she had allegiance, or she was a subject or a citizen of a foreign power. Now, the answer to the first request came back. If I understand the first question correctly, the answer is that no document is relevant in this context. Since the Statute of Westminster 1931 and the Australia Acts 1986, there is no document that allows British law to be used in Australia. Australia is now fully independent. So there's no document that allows British law, and this is unarguably British law, and as I said later, you'll see where even the High Court in England state that. So that answer has literally ruled out the Constitution. And the other document I asked for, no document overrides S44. The Stykes versus Cleary case 1992 clearly shows that the Constitution takes precedence in this matter. So S44 must prevail. And S44 reads, any person who is under acknowledgement of allegiance is the key word, obedience or adherence to a foreign power, or is a subject or a citizen, or entitled to the rights or privileges of a subject or a citizen of a foreign power, shall be incapable of being chosen or sitting as a senator or a member of the House of Representatives. So section 44 says if you have allegiance to a foreign power, you are incapable of being chosen or sitting as a senator or a member of the House of Representatives. That's quite clear. And section 42 says, every senator and every member of the House of Representatives shall, before taking his seat, make and subscribe before the Governor-General or some person authorised by him an oath or affirmation of allegiance again in the form set out in the schedule to this Constitution. So the oath they have to swear is in the schedule to this Constitution, which I showed you earlier, and it reads, I, their name, do swear that I will be faithful and bear true allegiance again to Her Majesty Queen Victoria, her heirs and successors according to law, so help me God. And there's a note at the bottom, the name of the King or Queen of the United Kingdom of Great Britain and Ireland for the time being is to be substituted from time to time. So now it would read, of course, Queen Elizabeth II, her heirs and successors according to law. But it is clearly to the United Kingdom of Great Britain and Ireland. The High Court has ruled the United Kingdom to be a foreign power. So under section 44, the one they ruled Heather Hill out on, clearly all members of Parliament have sworn allegiance, as the key word, to a foreign power. So says the High Court. So how can they sit in the Parliament? Section 44 rules them out. And while we're on that sort of subject, there's qualifications of members in section 34. And this is to do with Heather Hill again, and it says, he must be a subject of the Queen, either natural born or for at least 5 years naturalised under a law of the United Kingdom or of a colony which becomes a state, or of a commonwealth or of a state. So it's telling you there that you must be a subject of the Queen to qualify for election. And why wouldn't it? This is a constitution for a colony. Under this constitution we are all subjects of the Queen. That is, of course, before the 1948 Citizenship Act was passed. However, it would appear that Heather Hill was probably the only one qualified to sit in the Senate, if she has to be a subject of the Queen. So it would seem that the High Court has ruled directly against section 34 of the Constitution. Now this is the Royal Styles and Titles Act 1973. There were two of these passed, one in 53 and one in 73. This is the latest one, so this is the one we'll deal with. And the title given to the Queen was Elizabeth II, by the grace of God, Queen of Australia, her other realms and territories, Head of the Commonwealth. So that is the title given to her in 1973. And there's no problem with them giving her that title, none at all. They could give me the title King of Australia tomorrow if they wanted to, but what they cannot do is bestow the authority upon such a person to appoint governors and governor-generals. There is simply no provision for that in the Constitution. That right remains solely with the Queen of the United Kingdom, and we're told now that she no longer has it. Okay, now here is the latest Governor of Queensland, Quinton Bryce, and this is her commission, and she's appointed by Elizabeth II by the grace of God, Queen of Australia and her other realms and territories, head of the Commonwealth. Exactly that title created in 1973. And on the second and last page of this commission, it says, given at our Court of St James this 4th day of March 2003 in the 52nd year of our reign. So you would take 51 years from 2003, that brings you back to 1952, and I guess with the month of the year it could even possibly be 1953. So that clearly is the Queen of the United Kingdom. Clearly. It certainly cannot possibly be the title at the front here given to the Queen of Australia in 1973, who has issued this commission. So I believe the government is living on a lie with this Queen of Australia business, and I think that is a mistake they have made, that clearly that's the Queen of England at the Court of St James, and you do your mathematics, and clearly on the front page it's the title created in 1973. And here's the one for Philip Michael Jeffrey, our present Governor-General. Again, it's Elizabeth II by the grace of God, Queen of Australia, her other realms and territories, head of the Commonwealth. Appointed and given his commission by the Queen of Australia. And this is letters patent, issued in 1984, and again by the Queen of Australia, exactly the title given in 1973. So I believe that after this date, 1984, this date of this letters patent, no Governor-General could possibly claim to have valid legal authority, because the Queen of Australia simply doesn't have authority to issue letters patent, and give them their commission too, of course, but just does not have that authority. Now, it gets more interesting though. The Governor-General, it states here, before assuming office, a person appointed to be Governor-General shall take the oath of affirmation of allegiance and the oath of affirmation of office in the presence of the Chief Justice or another Justice of the High Court. So the Governor-General has to swear an oath. And on the last page of this letters patent, and letters patent by the way is letters of instructions to the Governor-General, it states, for the purposes of these letters patent, a reference to the oath or affirmation of allegiance is a reference to the oath or affirmation in accordance with the form set out in the schedule to the Constitution of the Commonwealth of Australia. So there you go. He has to also swear that same oath that the politicians swear, and I'll just run through it very quickly again. I, his name, do swear that I will be faithful and bear true allegiance to Her Majesty Queen Victoria, her heirs and successors according to law, so help me God. And as we said before, the note says that it would now read the Queen Elizabeth II, but it is crystal clear here in the note that it is to the King or Queen of the United Kingdom of Great Britain and Ireland. So there again you have letters patent issued by the Queen of Australia, the title created in 1973, but he is swearing allegiance to the Queen of the United Kingdom. I believe another mistake. Here we have the Australia Act, which was passed in 1986, and that was referred to in the Heather Hill case, you may remember, where they said we're certainly an independent sovereign nation after this Act. Well, we were much before that, and even High Court judges will admit that, but now you can argue as to the validity of the 1986 Act, and with good reason. However, the fact is that it is passed through the Parliament, it has had royal assent, and whether we like it or not, it is law. And the first clause of this Act says, an Act to bring constitutional arrangements affecting the Commonwealth and the States into conformity with the status of the Commonwealth of Australia as a sovereign, independent and federal nation. So, as the judges said, clearly after this Act, we are a sovereign, independent federal nation. However, in Newcastle, in December 2002, there was a court case at the District Court, and the District Court judge made this statement. Now, I hear what you say about the Queen of Australia as opposed to the Queen of the United Kingdom. Bear in mind that we are still a colony, effectively a colony of the United Kingdom. We still do not have a separate sovereign nation. So that's in December 2002, several years after the Australia Act was passed. So it would appear that we even have judges who aren't aware of whether we are an independent sovereign nation or a colony. I think you can probably start to see by now that Australia is a legal basket case. Now, I wrote to the Attorney General and I asked him if the Magna Carta and the Bill of Rights still applied in Australian law. And he wrote back and he said, the statutory enactments of Magna Carta and the Bill of Rights were received by the Australian colonies and may therefore have a continuing application as part of the law of Australia. However, that application may vary between Australian jurisdictions, and of course that is state and federal parliaments, to the extent that the enactments continue as part of the law of Australia. They may be amended or repealed by the relevant Australian legislature. So he's saying that the state or federal parliaments can amend or repeal the Bill of Rights and the Magna Carta. I find that a fairly astounding sort of a statement. However, you'll see that that is totally supported by the High Court. Now here we have Bryant versus the Commonwealth of Australia in 2002. Joe Bryant took this case to the High Court and he argued exactly that same thing, that he believes the Magna Carta and the Bill of Rights should still apply in Australian law, given that our Constitution is British law, and he did a pretty good job of arguing it too. However, Judge McHugh, when referring to the Bill of Rights and Magna Carta, said this: those rights that you assert, unfortunately from your point of view, just did not exist after the Constitution came into force, except insofar as the parliaments of the Commonwealth and the states allowed them to continue in force. But if they wanted to change them, they were at liberty to do it. That is the whole purpose of a constitution, to change laws. So there again you have the High Court stating that the states and federal parliaments could change the Magna Carta and Bill of Rights. They were at liberty to do it. Exactly what the Attorney General said to us. Now, I've got another High Court case. This is Essenberg versus the Queen. This was in the year 2000. Similar argument. There are more, but I think two cases is enough to prove the point. And similar argument about the Magna Carta and the Bill of Rights. And the judge said the following: but is not the problem you face that Magna Carta and the Bill of Rights of 1688 are not documents binding on Australian legislatures in the way the Constitution is binding on these legislatures? Any legislature acting within the powers allotted to it by the Constitution is entitled to legislate in total disregard of the Magna Carta and the Bill of Rights. So there you are. He's saying that they can legislate in total disregard of the Magna Carta and the Bill of Rights. So clearly the High Court is virtually telling you that they just do not apply at all. And in that same case, Essenberg versus the Queen, the judge went on to make this statement: but Parliament, some authorities would regard it as regrettable, can in effect do it as it likes. It is said some authorities could legislate to have every blue-eyed baby killed if it wanted to. Now that's a statement from a High Court judge. That makes you wonder where we're going. Alright, I wrote to the Attorney General again and I said to him that it's my understanding that if we are an independent sovereign nation, it's my understanding that we, the people, are sovereign. And he wrote back, and this is Philip Ruddock, and it's actually signed by Philip Ruddock, which is pretty unusual. And at the end he said this: "You may, however, be interested in some observations of the current Chief Justice of Australia, the Honourable Murray Gleeson AC, in a recent publication, The Rule of Law and the Constitution, ABC Books 2000. The Chief Justice states at page 6, the sovereignty of our nation lies with the people, both as a matter of legal principle and as a matter of practical reality." So that's the Chief Justice of the High Court. You can't go too much higher than that. And he is saying that we are sovereign as a matter of legal principle and practical reality. However, if you go into a Queensland court, I can't say what the other states are, what their legislation and so on is, but this is what a Queensland police officer swears as his oath: that I will well and truly serve our sovereign lady, Queen Elizabeth II, her heirs and successors according to law. So he's calling her our sovereign lady. The Chief Justice is saying we are sovereign. And wherever you see Queen Elizabeth II, her heirs and successors, that is the Queen of the United Kingdom. Because in both Royal Styles and Titles Acts 53 and 73, there was no act of succession passed for heirs and successors. So the Queen of Australia has no heirs and successors. So that is the Queen of the United Kingdom. However, it gets better. In that same court you will have legal practitioners who swear this oath: I, their name, do sincerely promise and swear that I will be faithful and bear true allegiance to Her Majesty Queen Elizabeth II as lawful sovereign of Australia, and to her other realms and territories, and to her heirs and successors according to law. So there in that court you will have legal practitioners swearing allegiance to Queen Elizabeth II, her heirs and successors, as lawful sovereign of Australia. So that's fairly amazing that you have solicitors swearing that when the Chief Justice of the High Court says we are sovereign. The magistrates' regulation is the same: Queen Elizabeth II, her heirs and successors. And even under our Queensland Constitution 2001, the politicians swear the same. I, their name, do sincerely promise and swear that I will be faithful and bear true allegiance to, and Her Majesty's name has to be put in there, as lawful sovereign of Australia, and to her heirs and successors according to law. So there you have the politicians in Queensland, I can't say what other states do, swearing allegiance to the Queen of the United Kingdom as lawful sovereign of Australia. And it seems to me that if England indeed is a foreign power, as the High Court states, all these people swearing allegiance to that foreign power could possibly be charged with treason. Now I wrote again to the Governor-General, Major Philip Michael Jeffrey, and I wrote to him regarding clause 68 of the Constitution, which says, the Command-in-Chief of the Naval and Military Forces of the Commonwealth is vested in the Governor-General as the Queen's representative. So that's a crystal clear statement. He is the Command-in-Chief of the Naval and Military Forces. And of course that was put in there for a good reason. That was your separation of powers, so that you didn't have a dictator in control of the Army, the High Court and so on. And I got a reply back when I asked him to forward me the documents that he issued to John Howard authorising him to send our troops overseas. And the answer was, the Governor-General appreciates the time and trouble you have taken writing to him about your concerns. However, the title of Commander-in-Chief held by the Governor-General under section 68 of the Constitution is a titular command This does not entitle him to intervene in the administration of the Australian Defence Force. So there you are. They're saying there that John Howard can do what he likes with the Defence Force, and the Governor-General's titular only cannot intervene. Well, that's certainly not what it says in section 68. That is crystal clear. So as you can see, our separation of powers has gone out the window. And just to further stress that point, there's a very dedicated group of people that took this whole business to the High Court Chancery Division in England about legality in Australia. They went right through to the High Court in Australia and of course did no good, because the High Court wasn't about to rule that the Queen of Australia had no authority to appoint Governor-Generals and so on, because the Governor-General actually swears in the High Court judges. So they weren't about to declare themselves illegal. So there again, the High Court is again supposed to be a separation of powers, but they're selected by politicians, sworn in by a Governor-General appointed by the Queen of Australia. So, as I say, your separation of powers is gone. We just don't have it anymore. However, this case went before Mr. Justice Lightman in the Chancery Division, as I said, of the High Court. And he made a couple of interesting statements, although he was pressured not to, but I won't go into that. And he said, well, the issue raised is an issue of construction of the 1900 Act, which is this Act, a United Kingdom statute. So there you are, he is telling you that this is still United Kingdom law. It is an issue that has no significance or consequence in this country. The connection with the United Kingdom is only historical in the sense that the 1900 Act was passed by the legislature here. On the other hand, the issue has potentially substantial consequences in Australia. Well, you'd have to agree with that. It would have substantial consequences, because the High Court has ruled that this is the law of a foreign power being used in the sovereign independent nation of Australia. And he went on to say, in my judgment, this court has no jurisdiction to determine the issues raised in this action. They are not justiciable here. Well, if England's an independent sovereign power, I'd have to agree with that. We can't have foreign courts making rules for ourselves unless we have such an agreement in place. And I would agree with that. But he also went on to say this: as soon as Australia became independent, the 1900 Act, the Constitution, ceased to have any effect as an exercise of sovereign power of the United Kingdom. So he's telling you that this document no longer has any sovereign power from the United Kingdom. And it is still, as I keep saying, British law. And we've heard where the Queen from the British Foreign Commonwealth Office, the Queen of the United Kingdom, no longer has authority, executive authority. So clearly British law and the British Queen no longer has authority in Australia, and yet it's still being used. Now, I wrote again to the Attorney General's office. This was just prior to the 2007 federal election, and I asked him for two